Smoke royalty. What is smoking with y'all? The laser attached to the black tool stronger than.
Dark, you're the battle rap.
No. When you came across battle rap, like.
But once I got to middle school, I might have stayed.
Go ahead, finish your story. Go ahead.
Being literal. So that,
and that's what I'm saying. Like, this is it is the same. I'm not gonna lie to you because they use
Smoking TV.
I ain't looking for problem, bitch. I am the problem. You want it, you got it. So here you go. Look, I came with a smile, but you want to smoke. Pistol with me, a nigga, and take it home.
Smoke royalty. What is smoking with y'all, man? Hey, we is here. And we got the Norbes versus URL lawsuit. You did what I'm saying. Shout out to the two for you. Know what I'm saying. I don't know where this nigga is getting all of this info from. I don't know where this nigga is getting the footage from. But keep it coming, young nigga. Keep it coming. Pause if need be. Man, today, man, Tooth, he streams some more of this shit, right? And it's right after, if you haven't seen the first one, go back to my last video, watch the first one, and then come back, right? Norbes' lawyer, you know what I mean? They basically laughing at him, you know what I'm saying? They telling him, like, this is a sad case, so on and so forth, right? Today, we get URL lawyers in there.
Thank you. May it please the court, James Senator, prior Cashman. I think the court has actually hit, well, let me take one step back.
I think you should.
Yeah.
Don't assume anything from the questions on the first half.
Why I'm retreating, Your Honor. From URL's perspective and from the perspective of the respondents, there's really two issues here, and the court's only seen to touch upon the second, and that may be where you want to focus, but I'll nonetheless proceed. In our mind, the first question and the gating question that should be answered is, should the court even consider the amended complaint? And the answer to that from our—
Well, the court below already did. Well, that horse has—
yeah.
That train left the station.
Okay, Your Honor, and I'll stipulate to that, and I realize I'm belling into a cannon. I'm not going to persuade you, but if I may just, if you do actually look at the order, the second of the dismissal orders.
We always do. I love it when lawyers say that.
I'm sure you have, and I apologize if I'm being presumptuous or assuming that you did not do something. But it does say for the reasons stated on the record. And when you actually look at the hearing transcript, what the court says is, I'm not going to rule on the proprietary. I'll accept it as the operative complaint. However, it is improper. You have procedural mechanisms under the CPLR. You could have sought to replead. You could have sought to re-argue. You should have appealed. They did none of that.
Could you just focus on the real issue?
Yes, I may. Yes, of course. So to answer, I think, where the court was going. So now to the second issue. So if we considered the amended complaint, which the court seems like it will, have they stated any of their causes of action? And the answer is they have not.
This guy is working and developing your business out of the goodness of his heart. Well, he did this just because he likes you guys. Come on.
Well, I would that all employees. First, I think.
An employee now?
No, he's an independent contractor, but all employees, all independent contractors, they all add value. They all add a service that helps benefit a company.
And they don't do it for free, right?
Keeping in mind, there's no allegation that he wasn't paid for his services. I understand there's allegations that he wasn't paid for all of his services, but to be a partner, to look at the essential elements, and the First Department has ruled on this many times over, you have to have shared intent, you have to have an agreement, and profit losses.
Is there evidence that he held publicly of URL?
Is there allegations of that? Is that was the question?
Evidence, however you want to put it.
Well, there's certainly no evidence of it. I believe he said that they told him he was a partner, and those are in claims that were dismissed.
And what about the YouTube interviews where other partners reference to him as being a partner of URL?
I don't believe there's ever the use of the term partner, and I believe even if the term partner was used as used in the colloquial sense, I believe it says is we're the members here. This is who URL is. But
well, as your friend pointed out in his argument, this is a 3211. We have to view the pleading in the light most favorable to his client.
Sure.
So if there are inferences to be drawn from something, we should be drawing them in his favor, not in defendant's favor.
Well, granted, I would stipulate to that. But I would say, though, even if I said that someone is my partner in a colloquial sense, it doesn't relieve them of pleading the elements of the cause of action. You ask them point blank, where in your 442 paragraph complaint did you say that you shared losses? He never. Keep in mind, this is a 10-year factual predicate. You can't identify one instance over 10 years where he shared in losses on a startup that by their own account made no money. It's not there because it didn't happen. And it's
why are his allegations at 345, 346, and 347, paragraphs 345, 346, 347 of the amended complaint at this juncture insufficient? Where at 347 he says at the meetings, which he referenced in the prior paragraph, that where we would talk about profits and losses. At the meetings, plaintiff and defendants agreed to share profits and losses from events equally.
So if you look at the first department's prior decision in Slavicus, that is a conclusory allegation. And I think it does bear relevance here that in the first 15-page motion to dismiss, Judge Oscar—
How else would you assert that? If that was indeed the agreement, if that actually happened, and I wasn't there, I don't know, but if that actually happened, how else would he be able to put that forth other than the way he has? Since there's no writing.
Respectfully, there's 10 years of practice here. You could point to one example where there was a manifestation of that agreement. I think the real critical part—
But you're saying that the plaintiff would have to prove that there was loss, as opposed to stating or showing that there was an agreement to share loss. What happens if the entity was really doing well and never had a loss? Doesn't that run counter to what you're arguing?
Under that factual scenario, I'd absolutely agree with you. I would say, however, the allegations are that it was an unprofitable enterprise and that the enterprise did not make money. That's according to the allegations. If I may, just to get back to your question,
in your motion for summary judgment, did you put forth evidence that that URL has suffered over the last 10 years some losses that only your clients paid for and that the plaintiff here did not participate in? Did you put anything like that as evidence in your motion?
Yeah, just
summary judgment.
Just to ground this, we're still at the dismissal stage. So it was—
Counsel, I asked a direct question. The answer to that question is yes or no.
We've never gotten to summary judgment, so the answer is no. This is not a motion to dismiss, Your Honor.
Yes, but you have to establish that you are entitled to summary judgment. And you said yourself, they haven't established that they would share in losses. A way of establishing that would be to show that only you guys paid the losses.
I can certainly say the discovery has borne that out, but we have not filed a motion for summary judgment. We're not seeking summary judgment. What we're seeking is that this court can affirm the two orders of dismissal. And I do think it's really important. You did ask— I do want to answer this question in paragraph 259. The question that was asked is, what did you share? Did you share in the profits? And if you actually look at the complaint, paragraph 259 is quite illuminating for the amended complaint. What it actually says is, well, I shared in the proceeds of some of the events, not all. If you're a partner, you share in all of the profits.
Thank you.
Thank you. Appreciate it. Thank you, Your Honors.
Counsel, you've got 2 minutes.
You know what I'm saying? And you know what I mean? We thinking it's gonna be different, you know what I mean? We thinking they gonna have their shit together or whatnot. Not at all, bro. It's more the same. Like, these are some PG lawyers. Like, I don't understand what's going on. They fumbling and bumbling all over the place, choking, stuttering, stammering, you know what I'm saying? Looking like some of these battle rappers out here, you know what I'm saying? This nigga Tooth called the judges judge titles. This nigga is wild, bro. But the basis, you know what I'm saying, is they going crazy, you know what I'm saying? It's not that the lawyers is going crazy, the judges is going crazy. They like, I feel like they feel like this is a waste of their time. And I don't know why. I mean, I kind of can guess that the basis of the case is kind of not all the way there, right? You know what I mean? And I'm gonna use that for lack of a better terms. Not, the case isn't fully developed, right? And I feel like the judges feel like it's a waste of their time. And that's why the judges is talking to these lawyers so damn crazy like that. You know what I'm saying? They cutting these lawyers off. You know what I mean? Answer the question. You know what I'm saying? You're not answer the question. You know what I'm saying? They're not even letting them get the explanation out. They're like, yes or no, nigga. Either way, man, it is what it is. Y'all let me know what y'all think about this down in the comments below. Y'all make sure to like, comment, and subscribe. You dig? Salute for those that deserve it. You feel me? I hope this can come to a resolve. You feel me? You know what I mean? And as always, man, I love the hell out of y'all. King.
My ace is polar, I can't control it. Hella bright motor, still driving slowly. Yeah, Ratatouille and ran into a cobra. Yeah, my nigga smoking really smoke some. Rio, the great Bambino, money like a phone number.